This is Barry's Alma speaking for Claim School Incorporated's blogs, Alma on Insurance. Today we're going to speak about pleading and why the failure to plead sufficient facts to show a breach of contract requires dismissal in a United States District Court, and that breach of contract evidence is required to sue for bad faith. Foremost Insurance Company, Grand Rapids, Michigan, moved the court to dismiss in a case entitled CNS Properties-1 LLC versus Foremost Insurance Company, filed in the United States District Court and decided on January 10, 2025. The lawsuit alleged that damages from Hurricane Ida caused insurance claims concerning 3 properties owned by the plaintiff. The properties were each covered by separate insurance policies issued by Foremost when they were damaged by Hurricane Ida in August of 2021. Plaintiff alleged that while Foremost had been in possession of sufficient evidence of the losses or had the opportunity to fully apprise itself of the actual losses and damages, it failed to pay the amount due under the policies required by Louisiana law. Plaintiff sued Foremost in Louisiana State Court, asserting claims under Louisiana law for breach of contract and bad faith damages. Foremost removed the matter to the United States District Court on the basis of diversity jurisdiction. Foremost moved to dismiss plaintiff's claims based upon the improper accumulation of claims and because the suit did not state a claim for which relief can be granted. The legal standard involved was Federal Rules of Civil Procedure 18 that provides, quote, a party asserting a claim may join as independent or alternative claims as many claims as it has against an opposing party. Under Federal Rule of Civil Procedure 12b-6, a defendant can seek dismissal of the complaint or any part of it for failure to state a claim upon which relief may be granted. To survive a Rule 12b-6 motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Dismissal is appropriate when the complaint on its face shows a bar to relief. The court analyzed the issue and found that regarding the insurance policies attached by Foremost, the court found that those are referenced in plaintiff's state court petition and are central to plaintiff's claims and thus may be rightfully considered by the court. The court found also that the plaintiff properly included the claims concerning each of the 3 properties in one lawsuit pursuant to Federal Rules of Civil Procedure, Section 18, (a), close parentheses. The allegations of the petition, however, were insufficient to support a breach of contract claim. The petition contained only vague and conclusory allegations and does not refer to specific actions or omissions by Foremost. Plaintiff alleged that Hurricane Ida caused substantial amounts of damage to the exterior, interior, roof, and other structures of the insured properties, that plaintiff provided timely notice of the loss event to the defendant, and that the court found that the plaintiff's petition, however, failed to state a breach of contract claim against Foremost because of the 3 elements of a breach of contract: the contract, the breach, and damage. The court reached the same conclusion with respect to plaintiff's bad faith claim because the petition merely set forth the legal standard applicable to Louisiana bad faith claims without providing factual support for plaintiff's allegations that Foremost acted in bad faith. The plaintiffs also asked if they lost on the first issue for leave to amend. And in his opposition brief, plaintiff requested leave to amend the petition if the court agreed with foremost that the petition was deficient. And while plaintiff has failed to explain how it would amend its petition, plaintiffs shall have 14 days to file an amended petition addressing the deficiency raised as to the sufficiency of its breach of contract and bad faith claims. The motion to dismiss pursuant to Federal Rule 12 was therefore granted, and plaintiff was granted 14 days from the date of the order to file an amended complaint. In my opinion, the United States District Court requires proper, detailed, and effective pleading when suing for breach of contract or the tort of bad faith, not just a parade of horribles alleged against the defendant with the statutory requirements without supportive facts. The USDC spent much of its opinion explaining to the plaintiff what is required to plead a viable complaint against foremost if such facts exist, and they will either comply or not. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about the blog and the videos, and let them subscribe to the blog and the videos. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.